For the record, he is charged with driving while intoxicated with a blood alcohol content of 0.15 or higher. Mr. Olagishin is acting pro se. I have appointed Andrew Freilich to stand by or to assist if Mr. Olagishin requests or if due process or the interest of justice calls for it. Now, you have a motion that you want heard today, is that correct?
Yes.
And I'd prefer that you take your glasses off and your cap off, if you would, as a courtesy.
Oh, yes, sure.
There you are. The glasses are okay. They look like you're facing some bright light or a
Yes.
window.
Let me
That's
see.
okay.
Is that better?
That's okay. No, it is not. Uh, the glasses reflect quite strongly, but that's okay. You can open that light up, whatever it was.
Oh, okay.
There you go. You look good. All right. I hope informally at this point, I hope that you are uh, well and that your loved ones are also. Mr. Olagishin, what is the motion that you wish to have heard?
Your Honor, I filed a motion and a demand to have the case dismissed for the violation of rights and lack of a speedy trial and the failure of the prosecution to prosecute this case.
All right. The violation of rights is very general, but the speedy trial issue,
Violation of rights to a speedy trial.
okay. All right. Mr. Olagishin, as I have mentioned to you before, uh, when you choose to act pro se, the court has to treat you as if you know what you're doing legally. So, with that, I will at this point, uh, you, sir, you have the motion. It is your floor. You may proceed to present your motion.
Yes. Your Honor, I would defer to. Oh, he's trying to page. Oh, okay. I'm not quite familiar with Zoom. How is this?
That's readable, but I can read it. I can see it.
Oh, okay. Yes. Yes. The motion filed is a motion to dismiss the case number 594-016 on the DWI with blood alcohol level 0.15 or higher. And this is for want of prosecution and for failure to prosecute by the state in the courts and for violation of my rights to a speedy trial.
Understand? Make your presentation.
Okay.
It takes.
Right. How do I exit out of this screen?
The share screen at the bottom.
Huh?
The share screen
Oh,
at the
click it.
bottom or in the upper right hand corner.
Uh-huh.
There should be an view options, exit, some.
Oh,
red
okay,
button that
okay.
says
Exit full
right
screen.
there.
Okay, I see it now. I was trying to go back to my screen. Yeah, I'm not quite familiar. Apologize. I'm not quite familiar with Zoom quite yet. Uh,
Judge, at this time, would you like me to go ahead and unshare the motion
Yes.
for the defendant? Okay.
All right. We're back, Mr. Olagishin. I
okay.
can see you, and I'm sure you can see me.
Yes, I can see you. I am trying to. This screen is. Okay, there we go. All right. I was trying to. I'm trying to toggle between these two screens here. Like I said, I'm not used to this. All right. Your Honor, I would refer to the case law, which is the Barker and the Wingo factors for speedy trial dismissal. Your Honor, I would point out and have the court take judicial notice that every time this case has been reset, and mind you, this case was the alleged the allegation, the alleged offense happened back in September of 2018. And between that time and now, that is a few weeks shy of 2 solid years. The state and the court has a duty to bring this case against the defendant. Since September 2018 to present, there has been various excuses from the county court 15, which the case has been already reset 3 times under Melissa Vera before it was transferred to your court in County Court 5, which I wasn't given no specific reason why it was transferred. And then since it's been in your court, we should take judicial notice that during the last setting in your courtroom, you did state for the record that if there was to be any reset in this case again, that you would make it a personal objective of yours to dismiss this case. Now, between the courts and the states, there has been their mix-up, but it is up to the court and the state who works in conjunction to bring a case against the defendant. I'm not the one to bring this case to trial. And since then, I have announced every time since I took over this case pro se in September 2019 that I have announced ready and being ready to proceed to trial with every reset date. And it's the court and the state's responsibility to bring this case to trial. The main reason why I do believe this case should be dismissed already is because, like I stated earlier, I have a right to a fair and speedy trial. There has nothing that has been speedy about this case since we've been sitting on this case for 2 years. And like I stated for the record, Your Honor, the last time I was there is nothing stopping them from resetting this case for the next 5 years if we're just going to reset every time. I have a right, just like uh, 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 um, every defendant in this court system, to a speedy trial. And there has been various prejudice that I've faced as a result of this case pending for 2 solid years. My life has been adversely affected due to the prejudice by the state and the court to bring this case to a speedy trial. Because of the delay, I've lost sleep. I have my insomnia, which I have. I'm a disabled military veteran. My health has gotten worse. I've suffered loss of income because for 2 years, this case has been pending. I am licensed by the Texas Department of Public Safety. And since then, my license has been in limbo. I've not been able to renew. I've lost income. I've lost my certifications. There has been wasted time and revenue. I've lost money. There's been a gross violation of my right. And to add to that, there are credible witnesses that would have been material witnesses to this case that are no longer available because of this delay. With this and these compounding factors, I would ask that you do grant the dismissal of this case, since the state and the court has failed with their objective to bring this case to a speedy trial.
Anything else, sir?
I believe that should do it, but just to also state for the judicial notice that you did state on the record the last time I was in your courtroom that if there was ever to be any reset on this case again, that you were personally going to dismiss this case with prejudice. So I do ask that you go ahead. I do pray that you fulfill that obligation that you gave the last time I was in your courtroom for this case.
Is that your presentation? Anything else?
Yes, sir.
All right. State your witness.
Your Honor.
Please, Mr. Olagishin, address the court.
Your Honor, could you please repeat the question, please?
I said, Mr. Edelman, it is his time to ask questions if he chooses. He represents the state. That's Andrew Edelman.
Okay.
Mr. Olagishin, you stated that you have suffered a variety of anxiety-related effects as a result of the pending of this case?
Yes.
Do those anxiety-related effects have anything to do with any of the other cases that have accrued against you in the
We are
intervening
not here
2
to
years?
discuss any other case. We are here to discuss specifically case number 594-016. As I stated earlier, let me just make sure I have that case number correct. I am not on trial today, July 22nd, 2020, for any other case, which is a non-factor in any other case, which is a non-factor and has nothing to do with any other case that we are discussing today.
Mr. Olagishin, there was a question. Do you have an objection to the question?
Yes, sir. I did just object to that question.
You think what?
Yes, sir. I did just object to that question.
What is your objection?
Those cases has no leverage on this case we are here on trial for today. We're here on trial for the DWI case. We're not on trial for any other case today.
All right. Your objection is overruled. You have raised the issue that you have suffered anxiety. Mr. Edelman is asking you questions about that anxiety. Please listen carefully and answer his question. Mr. Edelman, repeat your question.
So is it your claim that you suffer the results of anxiety because of this case only?
Say that again.
Is it your claim that you suffer anxiety and its physical manifestations as a result only of this case?
I never stated only. I'm saying I have suffered anxiety and its physical manifestation as a result of this case. Yes.
And how do you distinguish the anxiety that you experience as a result of this case from the anxiety that you experience as a result of the ag assault deadly weapon for which you're awaiting trial?
Objection. I never stated I suffer anxiety from those other cases. You know why? Because I'm dealing with this case. And number two,
Excuse me, Mr. Lagashi. He has asked you a question. He's entitled to an answer on the specific question that he asked you. You have to listen carefully to his question.
Okay.
All right. He asked you, Mr. Lagashin, is the anxiety that you claim and the physical manifestations, the physical symptomology that you feel, is it limited only to the result of this case, or do you distinguish it, or can you feel it differently from the anxiety you have from the aggravated assault case that he referred to?
My objection to that question is, why is any other of my case being brought up in this case if I'm on trial for a DWI case?
Okay, I will repeat to you again. I overrule that because whenever you raise a topic in a question by your testimony, by the way, I failed to swear you in, and I apologize for that. Please raise your right hand. You solemnly swear that in this proceeding, the answers and information you submit will be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
Pardon me? Pardon me?
Yes.
Yes, sir.
Yes.
All right. That's fine. All right. Now, back to Mr. Edelman asked you a question regarding your anxiety. And he is wishing, by the question generally, it appears he wants to see if you can distinguish the anxiety that you're feeling as a result of the DWI case versus any anxiety that you feel because of the aggravated assault felony case. Can you answer that question?
Yes, it is distinguishable. I deal with anxiety with this case. This has been my longest. This case has had 3 resets in your court already. It's had 5 resets altogether. It's had 4 previous resets in Melissa Vera's court. This case has kept my life in limbo. So yes, it is very distinguishable. This is also the case where they charged me with a fraudulent felony charge, which has no leverage on this case right now. However,
all right, excuse me.
Yes, sir.
Your objection, as I said, is overruled. He has asked a question. Apparently, I believe you have answered it.
Yes, it is
All right.
distinguishable.
All right, Mr. Edelman, you may proceed.
So, Mr. Olagishin, your anxiety is also distinguishable from the pending retaliation, the pending assault public servant bodily injury, the pending
Objection, Your Honor.
harassment of public servant.
Objection, Your Honor. And let me state for the record, while he is bringing these alleged charges into a totally unrelated case, let it be stated for the record that I was literally kidnapped on September 2019, which stemmed out of these cases. The prosecution can also verify there was no booking records for me ever being in detention that day. These are fraudulent charges that have been filed on me since the 2018 DWI incident, when I did make the mistake of mentioning a federal lawsuit to the deputies of San Antonio Detention Center and Bay County Detention Center, and they have made my life hell for the past 2 years. So yes, the anxiety that I feel has stemmed from the 2018 arrest, the September 2018 arrest for the DWI charge. All of this has been a systematic targeting as a result of my September 22nd, 2018 arrest charges.
Mr. Olagishin, you're gonna have to be a little more succinct in your presenting your objections, because this is not the time to argue the validity of cases. It's the time to argue the validity of the objection.
Your Honor.
Now, you're saying that you are objecting to the raising of the different or the discussion of different cases in this particular hearing on the DWI case. The fact is, again, listen carefully. You have raised in your testimony earlier, you raised the issue of anxiety. Mr. Edelman for the state has the right to question you about that. And you have said that you are, you have suffered anxiety as a result of this particular case.
Roger.
And he has the right to question you about that in depth to the extent he wishes to.
Okay.
To determine what anxiety you have from the other cases, because I'm sure you understand that having 3 or 4 or 5 or 10 cases, I don't care what they are, I don't really care about how many cases there are. If you're claiming you're suffering anxiety in one case, there's others that you can be asked about if you have anxiety in those cases.
I didn't suffer anxiety. I've had to deal with anxiety. I didn't suffer anxiety because of the case. I've had to deal with anxiety. There's a very succinct difference between the two.
All right. The semantics of it, I understand. I'm hearing what you're saying.
Your Honor, as a medical professional, it's not semantics. I have anxiety is a difference from me suffering anxiety.
I'm not going to debate with you, Mr. Olagishin. I have ruled Mr. Edelman can continue to question you.
Okay.
Your objection is overruled. Mr. Edelman, proceed.
I believe I left off on the assault public servant bodily injury that was alleged to have occurred on September 19th, 2019. Moving on, you can distinguish the anxiety that you feel as a result of this case from any anxiety that might result as from the pending ag assault with deadly weapon alleged to have occurred on November 24th, 2019, or the failure to ID fugitive alleged to have occurred on March 20th, 2020, or the terroristic threat peace officer alleged to have occurred on June 4th, 2020, or the resisting arrest or search or transportation alleged to have occurred July 16th of 2020.
And what's your question? Because all of this has no relevance with the case we're hearing right now. What's your question?
Your Honor, since the defendant has not lodged an objection, I would ask that the court instruct the defendant to answer.
I basically asked you to repeat your question, Your Honor. So I didn't refuse to ask the question. I asked him to repeat the question. What is the question? He just counted a list of charges that
Mr. Olagishin,
unrelated
you
to
have made your objection. You don't need to explain to me what you're thinking or doing.
Yes, sir.
Your objection at this time, again, is overruled.
So I asked him to repeat the question because I don't understand the question, for the record.
All right, that you're entitled to. You don't need to give me a long-winded explanation of why you're making the objection. The objection speaks for itself.
Okay.
Your objection is overruled. You may answer the question, sir, or you will answer the question.
I will answer the question, but I said for him to repeat the question because I don't understand what exactly he is asking.
All right, Mr. Edelman, would you be kind enough to repeat the question for the gentleman?
Is the anxiety that you experience distinguished, in this case, separate and distinguishable from the anxiety that you might experience in all of the other cases that you have accrued in the intervening 2 years?
Well, oh yeah, the other thing that I just realized is Your Honor, you swore me in. Was Elderman sworn in also? Because he is testifying on the record, yes?
No, sir. He is an attorney. And as an attorney representing the state, he is allowed to ask you questions in an adversarial fashion. And he is not a witness when he asks you a question. The question speaks for itself. So now you've heard the question at least twice.
It is.
Excuse me. You've heard the question at least twice.
Right.
You will answer the question, please.
Yes, sir. Since this case has been going on, it is distinguishable from every other follow-on case because this has been the longest running case. This has been the genesis of what I've had to deal with. And I have, I deal with anxiety. I don't experience anxiety. I don't suffer anxiety. I deal with anxiety as a result of this specific case because this was the second case in the genesis of what I've been having to deal with at the hands of law enforcement in this city. And I've been targeted ever since this DWI charge. So yes, it is a distinguishable factor from a medical standpoint, yes. It only has increased the more I've been targeted by law enforcement members of the state and officials of this city.
Thank you. No further questions.
All right. Mr. Olaishin.
Yes, sir.
Any other witnesses?
Your Honor, unfortunately, since the state and the courts has drawn this case out for such an extended period of time, thereby violating my rights to a speedy trial, I no longer have witnesses that would have been credible witness to this case.
All right, sir. So you don't have any other witnesses. Do you have any further? You have any further evidence of any nature that you wish to offer in this hearing?
I have, if you would make judicial note to the documents that was turned into you during our last setting in your courtroom. And by the way, the standby lawyer is also a witness who would testify to the fact that every time the state and the courts has reset for whatever reason, I have always announced ready, and at least 5 different times between the 2 courts that I've always had my announcement be ready, and the document turned into you during our last setting shows there had been at least 5 different settings, 3 from the previous courtroom, County Court 15 from Melissa Vera, and now 3 from your courtroom, County Court 5. And you said that gave that obligation that if there was any other reset for whatsoever reason, you would personally see to it that this case was dismissed due to the violation of my right to a speedy trial and how long this court case has been drawn out already.
Any other evidence, sir?
That should do it, sir.
Pardon me?
That should do it, sir. The
All
fact
right.
that this has been reset at least 3 times already in 2 individual courts surpasses the number of trials the state is required to bring this case to trial.
All right. The court will take judicial knowledge of the number of settings that this court has, that the defendant has gone through or experienced or dealt with. On this particular motion, the court denies the motion. You have not complied with the proof of the Barker v. Wingo requirements. You have spoken to them, but you have not met them as required by law. So, anything else, Mr. Olagishin?
Now, Your Honor, if the states required 3 resets, they have 3 tries to bring this case to trial. Right now, we've counted 6. And in a few weeks, this case would have been drawn out for 2 years. What is keeping the state from drawing this case out to 5 years? This is violating my right to a speedy trial. So even the fact that we've gone this long with this case and the back end of Wingo factors was not the sole basis for filing for dismissal of this case. The sole basis for filing for dismissal of this case is because of the lack of prosecution by the state and the courts, and the fact that my fundamental civil rights have been and legal rights have been violated by the courts for not granting me a speedy trial to this case. Then, in addition to that, you stated for the record, our last setting, that if there was ever any reset, you were to personally see to it that this case was dismissed, because it had already been dismissed 3 times. It has already been reset, pardon me, from County Court 15 3 times, and then was transferred with no due process given why it was transferred to County Court 5. And in your County Court 5, the last time I was in your courtroom was the 2nd time. As of June 22nd, this case was reset again. We could have had a virtual hearing, just we are doing right now. The state reset again to September 25th. So, Your
Mr.
Honor,
Olagishin, as I understood, this hearing today is of your motion to dismiss for want or for failure to provide you a speedy trial, right?
yes, sir.
The law tells me as a judge that I can grant that under certain circumstances. You have not met those circumstances. You chose to represent yourself. The attorney that was there to assist you, if needed, knows the Barker v. Wingo requirements. I can't just decide, well, I'm going to dismiss it, period. I have to decide it based on the law. And the law says, under these circumstances, you have failed to submit sufficient justification for me as a judge to dismiss this case because you had certain hoops, as it were, to jump through, or certain requirements, and you have not. And that's part of the problem of trying to be your own lawyer. You don't know all of the law. So I have ruled at this point we're going to reset this thing for the jury trial at the soonest date that is available, particularly due to the COVID-19 issues that have really cut the heck out of any kind of jury availability. So that is my ruling, and that is it for today. You will be sent notice of the new date for the actual jury setting. Mr. Edelman, anything further?
Nothing from the state, Your Honor.
Mr. Freilich, anything you wish to say at this point?
Mr. Freilich, you're on mute.
Yeah, I was actually saying out loud that I'm on mute. I'm trying to unmute that. Not at this time, Your Honor. Although I understand Mr. Ogoshin may attempt to re-urge this motion at a later date. I'm not sure if he wants to waive a jury trial and proceed as a bench trial. That's certainly his decision. But I don't have anything to add at this point in time, Your Honor. Thank you.
All right, then this hearing will be concluded. Mr. Olagishin, Mr. Freilich was appointed to assist him. If you choose to visit with him by computer or otherwise. I presume that would be the more efficient manner. He might be able to guide you. You might be able to submit a subsequent motion, but that's
Okay.
purely up to you, sir.
Okay.
All right, then it'll be this hearing is concluded. Thank you all for your time. Be blessed, be well, and be safe, all of you and your loved ones.